Non-commercial contract terminations.
444. How are terminations of non-commercial contracts conducted?
The right of the government to terminate a contract when its completion is no longer in the government's best interest has long been recognized. Non-commercial contracts may be terminated either for convenience or for default. This right has been the subject of many court decisions and boards of contract appeals decisions. The government has the right to terminate without cause and to limit the contractor's recovery. For example, recovery of anticipated profit is not allowed in a negotiated settlement, that is, the contractor is allotted allowable costs, profit, and other considerations in the judgment of the co. The settlement should compensate the contractor fairly for the work done and the preparations made for the terminated portion of the contract. Fair compensation is a matter of judgment and cannot be measured exactly. The use of business judgment by the co as opposed to adherence to strict accounting principles lays at the heart of a settlement. Cost and accounting data may provide guidance, but should not be used as rigid measures of whether settlement is appropriate in a given situation. In fact, in appropriate cases, costs may be estimated and differences and questions settled by agreement. Termination for convenience may be imposed at any time when termination is in the best interest of the government. Is a government right that provides flexibility to the government in the procurement process. Involves no fault or negligence on the part of the contractor. May be total or partial. Permits the contractor to propose an amount of compensation that it considers reasonable for accepted work up to the time of termination, costs for work completed plus a reasonable profit, and termination settlement costs. The final settlement amount is subject to negotiation by the CO. In addition to termination for convenience, the government is also entitled to terminate a contract due to inadequate contractor performance. Such terminations for default stem from the government's contractual right to terminate a contract when the contractor is failing to perform its obligations under the contract, usually amounting to a breach of the contract. The breach may be either actual, a currently existing failure to perform the contract, or anticipatory, a potential failure to perform the contract, for example, failure to make progress as related to the contract schedule. A contract may be terminated for default when the contractor does any one of the following: fails to deliver the supplies or perform the services within the time specified in the contract or within the time limit specified in an extension. Fails to make progress, so as to endanger performance of the contract. Fails to perform any other contractual provision. Figure 8.2 presents additional factors to consider before terminating for default.